Each of the panelists will be speaking to different aspects of equality, most important at this critical juncture, 40 years after the Charter, where substantive equality is under threat and where race and indigeneity are constructed as posing critical challenges and difficulty in accounting for substantive equality and the context of it. So first we have Professor Joshua Nichols of the Faculty of Law at McGill University, and he's speaking on Section 35 and the Charter, a review of the constitutional background of R.V. Sparrow. Next, we have Professor Colleen Sheppard, also from our own Faculty of Law, and former director of the McGill Center for Human Rights and Legal Pluralism. She'll be presenting to us on retrospective on substantive equality, fissures, and fracture. And last but not least, of course, we have Major Tamara Thermitus, who is a lawyer for close to 35 years, and she is a visiting scholar at our Center for Human Rights and Legal Pluralism. She'll be speaking to equality, rights, and access to justice. So with that, I'll hand it over to Professor Nichols, please. The floor is yours, Josh.
Thank you, Vrinda. So today I'll begin by unpacking what the court in Sparrow referred to as the constitutional background, and show you how the presuppositions that structure the Section 35 case law are reliant on the colonial era legal fiction of discovery. In short, while Canada may well be the leader in developing a constitutional doctrine of Aboriginal rights, this doctrine is foundationally flawed and in need of principled remediation. I'll then conclude by outlining some of the guiding principles that could help us move beyond the colonial limitations of the existing charter-like understanding of reconciliation. So the Canadian courts have struggled and continue to struggle with the legacy of colonialism. There are a series of cases that have relied on colonial legal doctrines that diminish the legal standing of Indigenous peoples by appeal to a hierarchy of civilizations. In these cases, the courts recognized the colonial version of Crown sovereignty, which allows them to posit that the assertion of Crown sovereignty strips Indigenous peoples both of their political existence and their lands, and leaves them with a box of rights. While it is a basic principle that the existence of the sovereignty of the Crown is not justiciable within Canadian courts, there is no principled basis for the idea that Crown sovereignty comes with plenary legislative power over Indigenous peoples or a superior claim to their lands. Thus, I'll refer to the notion that Crown sovereignty comes with legislative power underlying title as the colonial version of Crown sovereignty. This distinction is important because it reminds us that there's another version of Crown sovereignty that is based upon the treaties and is perfectly compatible with Indigenous peoples having inherent jurisdiction over their own lands. The current constitutional model of reconciliation is unable to meaningfully progress because it is based upon a colonial conception of Crown sovereignty that presents us with a narrative where Indigenous peoples are magically transformed into a cultural minority on their own territories by the mere assertion of European sovereignty. This is not the only model of reconciliation that the courts have developed, but it is the one that we need to honestly and openly account for if we're going to move forward towards an understanding of reconciliation that's based on forms of mutual recognition that we can see, however imperfectly, in the treaty process. Now, over 30 years ago in Sparrow, the Supreme Court recognized that Section 35 of the Constitution Act 1982, quote, "represents the culmination of a long and difficult struggle in both the political forms and the courts for the constitutional recognition of Aboriginal rights." Now, despite this, the court went on to hold that there was, quote, "from the outset, never any doubt that sovereignty and legislative power, and indeed underlying title to such lands, vested in the Crown." This statement establishes what they refer to as the background that allows the court to reconcile what they term federal power under 9124 with federal duty that is recognized and affirmed in Section 35. The result of this reconciliation is that Section 35 is subject to a justifiable infringement test adapted from Section 1 of the Charter. The obvious problem with this background is there is no legal explanation for the disappearance of Indigenous sovereignty, and this brings the background into tension with the court's prior rejection of colonial doctrines that diminish the legal capacity of Indigenous peoples. For example, as Justice Hall reminded us in Calder in 1973, the assessment and interpretation of the historical documents and enactments tendered in evidence must be approached in light of the present-day research and knowledge, disregarding ancient concepts formulated when understanding of the customs and culture of our original people was rudimentary and incomplete, and when they were thought to be wholly without cohesion, laws, or culture, in effect, a subhuman species. This principled interpretive precaution was later echoed by Justice Dixon in 1985 in Simon, when he stated that the colonial doctrines of civilizational hierarchy that Justice Pattison relied upon in Syllaboy, quote, reflect the biases and prejudices of another era of our history, and that, quote, such language is no longer acceptable in Canadian law. Nevertheless, the basis for the background that the court articulates in Sparrow fails to live up to this principled repudiation of racial prejudice. This background comes into view when we consider the precedents that the court relies upon and cites as authority for the proposition that there was never any doubt about the nature of Crown sovereignty. What they cite is the 1823 decision of the US Supreme Court in Johnson v. McIntosh, the Royal Proclamation of 1763, and 3 specific pages from Calder. The citations do not provide a stable foundation for the court's articulation of Crown sovereignty. It is not clear, for example, the precise principle the court cites Johnson v. McIntosh as supporting. Certainly, it would be a stretch to suggest that Johnson stands for the proposition that Indigenous peoples lost all sovereign and self-governing authority over their territories upon European discovery, and that such discovery subjects them to unfettered Crown legislative authority in perpetuity. After all, Chief Justice Marshall maintains throughout Johnson, Cherokee Nation, and Worcester that the rights of the Cherokee can only be lawfully extinguished by conquest or voluntary cession. The notion that Congress has a plenary legislative power over Indigenous peoples does not find its roots in the Marshall Trilogy. Rather, it is rooted in a line of thinking that we can see in the Taney Court in Rogers in 1846, which is fully articulated by Kagama in 1886. So as Justice Miller explains in Kagama, the power of the general government over these remnants of a race once powerful, now weak and diminished in numbers, is necessary to their protection, as well as to the safety of those among whom they dwell. It must exist in that government because it never has existed anywhere else. Because the theater of its exercise is within the geographical limits of the United States. Because it has never been denied. And because it alone can enforce its laws on all the tribes. Here we see an explicit articulation of the basis of the plenary legislative power of Congress over Indigenous peoples in the United States. This is not a legal rule. That is, unless we would like to embrace the notion that might determines the allocation of rights and responsibilities within a constitutional order in perpetuity as a legal rule. Thus, what we find in Kagama is a factual claim in legal dress. The claim is simply that Indigenous peoples lack the capacity to govern themselves. Returning to Sparrow, the citation of Johnson, we can see that there is no legal rule in this case that supports the Crown's claim that it has sovereignty, legislative power, and underlying title. Rather, subsequent US case law transformed the legal meaning of Johnson through selective citation and confused the distinction between factual claims and legal rules. This notion that it was a legal rule that stripped Indigenous peoples of their sovereignty is thus a misconception. As Justice Brennan helpfully explained in Mabo, Aboriginal rights and interests were not stripped away by operation of the common law on first settlement by British colonists, but by the exercise of a sovereign authority over land exercised recurrently by governments. But if the source of this sovereign authority is simply found in the historical action of colonial governments, are we not simply giving the biases and prejudices of another era of our history the color of legality in retrospect? The next legal source that the Sparrow Court uses is Calder. These are 3 pinpoint citations. They include Hall's summary of Johnson v. McIntosh, which details how discovery diminished the right of Indigenous peoples to complete sovereignty. It doesn't specify what diminishment meant for Chief Justice Marshall. On the same page, though, Hall cites the portion of Worcester where Marshall makes it clear that discovery did not affect the rights of Indigenous peoples. Rather, discovery regulated rights among European nations. The single citation from Judson is his statement that the origin of Aboriginal rights does not come by way of European recognition, but by the fact, quote, that when the settlers came, the Indians were there organized in societies and occupying the land as their forefathers had done for centuries. In short, here again, there is no support for the Crown's claim to sovereignty, legislative power, and underlying title. Despite this fact, the Canadian courts have consistently maintained this colonial version of Crown sovereignty and interpreted Section 9124 in a way that unilaterally excludes Aboriginal peoples from the division of powers and subjects them to the concurrent jurisdiction of both Parliament and the legislatures. This unilateral exclusion has no legitimate legal basis, and it has served to inform the approach that the courts have taken to the interpretation of treaties, the Indian Act, as well as the test for the infringement of rights and title. Now, there is another way of reading Section 9124, namely, as a power to negotiate with Indigenous nations as equal partners in confederation, and an obligation to honor existing agreements regarding Indigenous lands. The notion of Indigenous people being in an equal partnership with the Crown is not a new one. In fact, it was a recommendation of the Royal Commission in 1664 to Charles II. The possibility of this alternative interpretation of 9124 highlights the problematic foundations of the court's current approach to Section 35. If we turn our attention to the foundation of the court's interpretation of 35 in Sparrow, we see that the court's unquestioning assumption of Crown sovereignty, legislative power, and underlying title necessarily entails that the court is holding Indigenous peoples in a sovereign to subjects relationship on the basis of nothing more than a unilateral proclamation and a so-called background of colonial legal fictions. By interpreting 9124 as federal power over Indians and their lands, the court magically transforms Indigenous peoples into subjects. The only possible basis for this reading is a pernicious and racist set of 19th century European legal fictions that they have formally repudiated already. We would do well to remember that it is the Sparrow Court that introduces the term reconciliation into our case law, but we need to ask ourselves what exactly is being reconciled here. They take two provisions of two constitutional documents separated by 115 years, and with the magical words, never any doubt, they managed to maintain 9124 as federal power and thereby convert Section 35 into a paternalistic federal duty to be managed and mediated by the courts. This is the foundation of the so-called full box of rights approach to Section 35. If the background set out in Sparrow is simply accepted, we are driven to conclude that the Crown has sovereignty, legislative power, and underlying title, whereas Section 35 provides charter-like protections to a sui generis species of rights. This seems to fit the court's claim in the secession reference that Section 35 is an example of Canada's long tradition of protecting the rights of minorities. But this conclusion begs the question of what exactly happened to Indigenous sovereignty. In order to backfill this omission, the courts have either recharacterized the treaties as surrender agreements or simply adopted colonial legal fictions like discovery to diminish the legal capacity of Indigenous peoples without explanation, and thereby pave the way for the Crown's unilateral assertion of sovereignty as having the effect of locking Indigenous peoples into a constitutional straitjacket that they can only leave if they are able to avail themselves of the governmental institutions that were opposed upon them. Neither of these options provide a solution to the problem. Rather, they add into the troubling notion that the courts are providing the color of legality to the Crown's unilateral assertion of sovereignty over Indigenous peoples. Such a move necessarily brings us into what Professor David Deisenhouse has referred to as a gray hole in the constitutional order. It is concerning not only because of the negative effects it has had on Indigenous peoples, but also on the form of sovereign authority that it necessarily attributes to the Crown. That is a mysterious prerogative power that enables the executive to declare sovereignty over other peoples, dissolve their national character, and exercise plenary legislative power in perpetuity over them without being subject to proper judicial review. This is a kind of absolute sovereign authority that both the Glorious Revolution of 1688 and later the American Revolutionary War of 1775 were reacting against, and this rejection forms the core principles of the constitutional tradition that Canada has inherited. In other words, the stakes of simply accepting the background of Sparrow at face value are nothing less than the meaning of the rule of law in our country. This box of rights conception of Section 35 is by no means the only available approach. In fact, I argue that by removing the colonial legal fictions that persist within 9124, the legal paradigm of the Indigenous Crown relationship shifts from charter-like rights to jurisdiction within a federal division of powers. This also has the benefit of being an interpretive move that is squarely within the purview of the Supreme Court. As the guardians of the Constitution, they are tasked with interpreting its provisions, and so they cannot claim that they require a new provision from the legislative branches. Rather, they bear the full responsibility of retaining a reading of Section 9124 that can only be grounded on colonial legal fictions. By providing a principled legal interpretation of the nature of federal power under 9124, the court could no longer rely on it to treat Section 35 as if it were within the Charter and therein subject to the reasonable limitations clause of Section 1. This paradigm shift from charter-like rights to jurisdiction is indeed a realistic possibility, as the courts can draw from its own reading in the secession reference in Manitoba language rights cases to reset the relationship. This is what the Prime Minister's rhetoric of the nation-to-nation relationship should mean, as RCAP argued and as Indigenous peoples have consistently maintained for the last 250 years. Thank you very much.
Thanks very much, Josh. Brilliantly finished, bang on time. Colleen, the floor is yours.
Okay, so I was enjoying listening so much that I have to switch gears into presentation mode. As Vrinda's explained, this panel is on interpretive complexities, and to continue in that mode, I'm going to focus in on this concept of substantive equality that has emerged as central to the interpretation of Section 15.1 of the Charter. And I entitled my presentation Foundations, Fissures, and Fracture. And so just to begin, I think that we're all aware that one of the foundational decisions that set the groundwork for substantive equality, although in Andrews, Justice McIntyre didn't actually use that terminology. But some of the key components of a substantive equality approach to constitutional equality include principles including the idea that equality is about equitable outcomes. It's not simply about equal treatment. That equality may in fact require differential treatment, and inequality may result from the adverse effects of facially neutral treatment. So that treating everyone the same may actually have adverse effects resulting in inequality. And in developing that alternative equation, the court recognized that equality and governments must be responsive to societal inequalities and group-based differences, and sometimes treat groups differently in order to ensure equitable outcomes. Thirdly, the court recognized the importance of a purposive and a contextual assessment of the effects of laws and policies to try to discern what actually resulted in discriminatory group-based harms. Since one no longer had a process-based rule, equal treatment, one had to figure out when was equal treatment consistent with substantive equality and when was differential treatment potentially needed to secure equitable outcomes. So, and again, underpinning this shift in approach was a recognition of a more substantive as opposed to formal equality approach, was the idea that one of the key purposes of equality rights is to remedy and prevent discrimination against groups that have historically and that continue to experience social, political, and legal disadvantage. So equality was not simply about rational treatment of different symmetrical groups. It was about asymmetrical power relations of subordination and inequality. So that was the basis that, and most of the justices continue to refer back to this important Andrews decision in 1989 as the foundation of substantive equality. What happened in the intervening 30-some years? What I argue is that there are little fissures in this substantive equality foundation that recurred throughout those 30 years. Not always acknowledged. Sometimes they were inadvertent, or sometimes they were embedded in the doctrinal complexities of or application of various discrimination or equality cases. One recurrent uncertainty was how to assess inequitable group-based disadvantaging effects, how to know whether similar or differential treatment was consistent with substantive equality. There was also the emergence of a very formalistic, in some cases, a formalistic comparator group analysis that created significant complexities and often rendered group-based harms either invisible or made them seemingly reasonable based on the choice of comparators that the court used. In some cases, there was a failure to conclude that the state actually is responsible for responding to inequities in society. The courts would argue that the inequality that resulted was simply a private individual choice or ensued from pre-existing societal inequities. Therefore, it was outside of the purview of state responsibility, reinforcing a kind of negative rights paradigm. And finally, and these are just some examples of the fissures, there were difficulties in proving discrimination, particularly as the court began to adopt theories of adverse and systemic discrimination, amassing sufficient evidence by the claimants to prove these complex societal inequalities that were perpetrated or reinforced by law proved difficult in some cases. So if we go forward, and I wanted to just focus most of my presentation on this landmark judgment on substantive equality in 2020, the Fraser and Canada case. I thought I'm going to highlight some of the key developments in that decision by Justice Rosalie Abella, who is often seen as critical to this ongoing commitment to substantive equality. She, of course, was the single commissioner in the Royal Commission on Equality in Employment back in 1984. She recommended the development of employment equity. She articulated this idea of systemic discrimination. She's been a constant supporter of the idea, at least, of substantive equality. I haven't agreed with all of her judgments, but certainly in Fraser, she is writing one of her last, her last major decision before her retirement, which she took in July 2021, trying to put everything in the judgment that would clarify the situation with respect to substantive equality. Now, what was the case about? It was about whether the negative pension effects of participating in a job sharing program used predominantly by new mothers in the RCMP violated constitutional equality rights. So, and as some commentators have suggested, this is not the most significant problem of inequality in society, but it is an important constitutional question of equality. It deals with a relatively advantaged group of women claiming sex discrimination, women in the RCMP. Now, what was this job sharing program about? RCMP members could work reduced hours. They would basically share a job with another RCMP member, and those doing it working reduced hours in this job sharing program were predominantly women with young children. From 2010 to 2014, the evidentiary basis for the case, 100% of the members working reduced hours through job sharing were women, and almost all cited childcare as their main reason for doing so. The challenge in this case concerned the pension benefits that were available to job sharers, and specifically, although it's quite technical, whether they could buy back pension benefits for the time that was reduced through the job sharing program. Now, what are some of the important dimensions about substantive equality that we're left with in terms of this case, and what are some of the fractures? Because what I argue is that in this case, although there'd been various fissures over the course of 30 years since the Andrews case, in this case, we see the court openly fracturing very significantly. One fracture is about a substantive equality itself. And Justice Abella affirms the promise of substantive equality, saying it is the animating norm and philosophical premise. She writes, for over 30 years, it's involved identifying the presence, persistence, and pervasiveness of disadvantage based on enumerated or analogous ground. It's rooted in the rejection of a sameness or formal theory of equality. She also emphasizes that there's no rigid template. The goal is to examine group-based harm through the lens of economic, social, psychological, physical, and political harms and exclusion. She says we should examine group-based harms in light of systemic and historical disadvantages. And I just should disclose that she did cite my work in her decision, and so I'm biased in that way. And she cited many feminist scholars who had been working away for years on issues relating to equality. And it was interesting that she incorporated a lot of that academic scholarship into one of her last big judgments on equality at the court. Now, in response, however, you see these emerging voices of dissent. Justices Brown and Rowe write, for 30 years, this court has struggled to define the term substantive equality. An intelligible and principled definition continues to be elusive, and that there's a lack. The lack of definition is antithetical to the role of the judges. The legal test lacks defined bounds. Courts are being truly arbitrary. It's an unbounded rhetorical vehicle by which the judiciary's policy preferences and personal ideologies are imposed piecemeal upon individual cases. It's interesting that here we see equality rights subjected to this critique, when in fact, almost all law is subject to the ideological preferences of judges. Certainly, the presentation we just heard reveals deep ideological issues. Okay, the second, so one is this fracture on substantive quality. A second, I'm just going to point out really three divergences. The second important dimension of this case is a reaffirmation of adverse impact discrimination. There had been some questions about it and some issues relating to how to prove it with respect to statistical and other both quantitative and qualitative evidence. But you see Abella writing that it is a central trend in the development of discrimination law, marking a shift away from a fault-based conception or a perpetrator perspective to more of a criminal law, to an effects-based human rights approach that critically examines systems, structures, and their impact on disadvantaged groups. And then she recognizes the negative effects of the adverse effects of the pension plan scheme on the RCMP members who are participating in job sharing, finding it has a disproportionate impact on women, that the structural inequality within pension plans has tangible impacts for women, that the RCMP's pension plan design perpetuated the longstanding source of economic disadvantage. Now, in contrast, in one dissenting justice, Justice Cote, actually fails to recognize adverse impact in this context, finding instead that the distinction is not gender-based. It's not on the basis of being a woman, but being a woman with children. So you see this sort of retreat to a very formalistic conception of equality distinctions and a non-recognition of adverse impact in the reasoning of Justice Cote. Also troubling is the ways, and this is more difficult to pull out of this decision, but Justices Rowe and Brown recognized a sex-based distinction, but then in looking at whether or not there's harm, they switch back to a part-time versus full-time, part-time, they treat job sharers as equivalent to part-time workers and argue that it's fair and reasonable, non-arbitrary, to prorate pension benefits and to treat job shares as equivalent to part-time workers. I don't want to get into all the technicalities, but I argue that there's an erasure of gender in the ways in which they revert to a fairly technical distinction between job shares and part-time workers. Oops. Okay, I just lost my spot here. Okay, and finally, this third dimension, I don't see my clock here, so do I have another few minutes, Nandini or Vrinda?
You have 5 minutes, Colleen.
Okay, great. Okay. The third dimension that I wanted to highlight is equality rights require governments to take into account inequalities in society. And now this is an important idea that resonates with some of the ideas we talked about earlier with respect to positive or negative rights. What you see in Justice Abella's judgment is a reaffirmation of the idea that Section 15.1 requires the state to take into account systemic disadvantages affecting members of protected groups, even if the state itself did not create those inequalities or systemic disadvantages. And the classic case was the Eldridge case, where you had hearing impaired and deaf patients who needed sign language interpretation in order to have equitable access to the publicly provided healthcare system and medical services. In this case, she finds there's a breach of Section 15.1, not because women continue to have disproportionate responsibility for childcare and less stable working hours than men, she says, but because we can link that societal inequality to the ways in which the government, through its pension plan, institutionalizes those traits and renders it a basis upon which to unequally distribute pension benefits to job sharing participants. This, she calls, is discrimination reinforced by law. So you see a recognition of inequalities in society, but a concern that legal regimes, pension plans, other laws and policies need to take into account and respond to those societal inequalities. That's the essence of substantive equality, really. But unlike that position, you can see, and this is a more troubling dimension of the dissenting Justices Brown and Rowe's opinion, they say any disadvantage here was caused not by the government action, but by the unequal division of household and family responsibilities and social circumstances, such as the availability of quality childcare. To find a violation would render the state responsible for discrimination it has not caused. That's the key difference here. Now, that's not true. What Abella concludes is the state needs to take into account inequalities in society more generally, including the unequal division of childcare in the family. And one has to look at the interplay between government policy and law and societal inequalities. But the dissent does not view it that way, instead suggests that Section 15.1 does not impose upon governments the obligation to take positive actions to remedy the symptoms of systemic inequality. It's very confusing language around this positive actions and ameliorative programs, but I think you can see this basic divergence or fracture between the interplay between the government and societal inequality. So just to finish up then, I think it's important in light of that fracture to remember the inclusion of equal benefit of the law in Section 15.1. It's not just equal protection or equality before or under the law. There was the inclusion in Section 15 of equal benefit. And it's precisely equal benefit which mandates governments to take into, when they provide a benefit, they're required to ensure that that benefit is provided equitably to the community, to those in society who are to whom it applies. So you see this quote from Justice Abella: "It's unfortunate that as global jurisprudence has increasingly embraced substantive equality, my colleagues continue to endorse an approach which evokes a rejected pre-charter theory, whose effect was to deny access to benefits when that access required accommodation based on difference." So just to conclude, I think some of the lessons from this Fraser case, we do see an important endorsement of substantive equality by the majority, which is significant. An endorsement as well, an affirmation of adverse impact discrimination. I think a reminder that we need to think about the conceptual power and importance of equal benefit of the law, and that is a mandate to require governments to address societal inequalities that the state has not directly caused in its ameliorative initiatives, i.e. in its pension programs, in its healthcare programs, and that the failure to do so can be contested by historically disadvantaged groups. And one of the major problems, I think, are divergences between the majority and the dissent in the Fraser case was a different framing of the case, whereas the majority saw the pension program as the benefit that had to be provided equitably. The dissent narrows in on the job sharing program as a benefit that somehow could be provided as partially, or even providing some job sharing was better than nothing, and therefore they erased the problem of discrimination. So given the dissenting voices in a more overtly fractured court, I think it's important to continue to clarify and advocate for an expansive understanding of constitutional equality. And I'll just end there. Thank you.
Thank you very much, Colleen, for providing that interesting overview of where we are with substantive equality. And I think particularly we're at this critical juncture where substantive equality is under threat precisely because of people like Brown and Roe and their rejection of substantive equality. So all that sets the stage very nicely for our next panelist, who will be talking about structural inequality, race, and access to justice. Tamara Thermitus, the virtual floor is yours.
Alors, merci beaucoup. Ma présentation sera en français. J'aimerais d'abord remercier le Centre d'avoir permis de réfléchir sur un sujet si intéressant. Merci Nadine, merci Colleen, merci Vrinda. Alors, je vais vous parler un peu de la justice dans un contexte de personnes racisées. Je vais m'attarder plus particulièrement sur les questions structurelles, c'est-à-dire la diversité effective dans le cadre de la magistrature. Alors aujourd'hui, je ne pourrais commencer mon exposé sans souligner la nomination hier de la première juge noire à la Cour suprême des États-Unis. On ne peut oublier non plus la façon dont elle a été traitée lors de l'audition, lors de sa confirmation, ainsi que les questions qui lui ont été posées et la façon dont les questions lui ont été posées. Cette démonstration publique de la façon dont les femmes racisées sont souvent traitées dans l'espace public, avec un manque. Puis je veux dire, ce qui m'a frappé le plus, je pense, c'est de la voir pleurer à un moment qui devrait être pour elle, un moment qui devrait être la réussite, c'est-à-dire le soulier d'une carrière réussite, et de voir qu'on l'a placée dans une situation où on l'a humiliée et on l'a mis alors qu'elle était, puis je veux dire, il y a des informations qui ont circulé sur Internet démontrant que son record, comme on dit en anglais, était stellar. Bon, alors, la question d'accès à la justice, je pense que la juge en est une démonstration, c'est-à-dire que la représentativité au sein des tribunaux est fondamentale pour pouvoir avoir accès à une justice. Quand on parle d'accès à la justice, on ne peut pas parler seulement du fait que les dossiers sont entendus rapidement à des coûts raisonnables. Il faut que la justice soit une justice, et je reprends un peu l'essence des propos de la professeure Colleen Sheppard, c'est-à-dire que la justice doit être accessible dans le sens où on doit avoir des décisions justes, tant individuelles que socialement. Un constat s'impose. Depuis 40 ans, après l'entrée de la Charte, a eu très peu d'impact sur l'injustice raciale au Canada. Comme le souligne le professeur Joshua Sally Harrington dans un article à paraître, The Charter of White, Systemic Racism and Critical Race, Equality in Canada. Sur le plan de l'impact, le droit canadien en matière d'égalité devant la Cour suprême du Canada s'est avéré largement insaisissable pour ce qui est de promouvoir ou même d'aborder l'égalité raciale. C'est en ce sens qu'il soutient que nous avons une charte des Blancs. Or, la justice raciale demande des changements dans les systèmes qui nécessitent des transformations fondamentales et systémiques. Elle nous invite à analyser, à déconstruire les normes politiques, culturelles et économiques afin d'y débusquer les aspects les plus profonds et les plus complexes du racisme qui les imprègnent. Pourquoi la justice raciale tarde-t-elle à venir? Le défi est donc le suivant. Comment créer un système de justice dont les règles, les méthodes et le personnel tiennent réellement compte des questions d'identité et de diversité? Certains auteurs prétendent que le problème n'est pas la charte, mais ceux qui la plaident et ceux qui l'interprètent. On doit donc s'interroger sur les acteurs du système judiciaire ainsi que leur rôle. Une autre question se pose, est-ce que les juges qui proviennent de milieux homogènes sont en mesure de donner toute la portée émancipatrice à la charte? L'importance de la diversité au sein du pouvoir judiciaire. La branche judiciaire, tout comme les branches législatives et exécutives du gouvernement, doivent tenir compte de la population qu'ils desservent afin de maintenir, voire même de renforcer la confiance du public. Dans ce contexte, on ne saurait ignorer l'importance qu'ont les juges sur la vie des citoyens qui sont en contact avec le système judiciaire, tant dans le cadre de la justice civile, administrative et criminelle. Donc, dans une société démocratique, il est inacceptable qu'une institution non élue qui exerce le pouvoir judiciaire soit issue d'un groupe étroit et homogène qui ne reflète ni la diversité de la société, ni celle de la profession juridique dans son ensemble. Le fait de ne pas nommer la fonction judiciaire, à la fonction judiciaire des candidats bien qualifiés issus de milieux divers représente une exclusion de la participation au pouvoir. C'est une citation du Judicial Diversity Advisory Committee Report of England and Wales. La diversité touche à la légitimité, touche donc à la légitimité, à l'essence du processus judiciaire. Ici, on doit comprendre que la diversité qui implique une représentativité effective et non une instrumentalisation de la diversité qui ne vise qu'à affirmer les structures de pouvoir pour résister à tout changement de structure ou encore émancipatoire. Les études établissent une distinction entre deux théories à ce qui a trait à la représentation, c'est-à-dire soit la représentation descriptive ou encore la représentation substantive ou réelle. On entend par la représentation descriptive celle qui promeut des tribunaux qui ressemblent à l'ensemble de la population, ce qui est souhaitable du point de vue normatif. Elle se fonde sur l'idée qu'une magistrature diversifiée ne se justifie pas par le fait que les femmes et les minorités se comportent différemment des autres membres de la magistrature. Cette représentativité met plutôt l'accent sur la simple présence au sein de l'institution, ce qui lui confère un plus fort sentiment de légitimité et d'autorité. Quant à la représentation réelle, elle a pour prémisse que les femmes et les minorités apportent avec elles des expériences diverses enracinées dans leurs identités. Par conséquent, ils auront des points de vue différents. Pour que la diversité soit un apport à la démocratie et au système judiciaire, il faut que les juges soient en mesure de comprendre les inégalités, ce qui permet une représentation réelle. C'est pourquoi une plus grande représentation réelle au sein de la magistrature permet une meilleure compréhension des défis sociaux. De surcroît, l'expérience personnelle peut, dans certains cas, permettre une plus grande empathie, car on ne peut faire fi du fait que les jugements sont toujours politiques et que les politiques sont influencés par des dynamiques complexes d'identité et d'idéologie, comme le soulignait la professeure Colleen Sheppard il y a quelques minutes. Alors, récemment, le juge de la Cour fédérale rendait une conférence, une allocution sur diversité raciale au sein de la magistrature et il s'interrogeait sur ce que voulait dire la diversité réelle. Pour lui, une magistrature doit être réceptive et sensible aux expériences vécues par les groupes historiquement exclus. Autrement dit, la diversité réelle génère des réflexions, des actions et transcende le simple geste ou la simple apparence. Il ne suffit pas d'accroître la diversité de visages à grand renfort de chiffres et de statistiques. Cela n'aboutirait certainement pas à du changement. La diversité dans le processus décisionnel nécessite une diversité de réflexion sur le droit, son interprétation et surtout sur la notion de justice elle-même. Comme le concluait le juge Ahmed dans son allocution, pour que la diversité soit réelle, elle exige que des mesures soient prises au nom des juges racisés et de l'ensemble du système judiciaire. La diversité qui ne modifie en rien la façon d'agir est comme un masque. Elle peut paraître différente à première vue, mais notre logique ne tarde pas à réaliser qu'il s'agit d'un changement d'apparence peu convaincant qui ne permet pas de modifier la manière dont fonctionne l'entité derrière ce changement. La Cour suprême nous a donné des exemples dans certaines de ces nominations. On se rappellera l'article qui avait été écrit par les professeurs Bello et Johnson. Les femmes juges seront-elles de véritables différences? Réflexion 20 ans après la nomination de la juge Wilson. C'est l'article qui porte le même texte. Alors, ces deux professeurs soulignaient que Bora Laskin ainsi que Johnson Pinker avaient apporté quand même une vision différente dans certaines de leurs dissidences. On ne peut non plus faire fi du cas récemment du juge Gascon qui a démissionné de la Cour suprême après avoir révélé qu'il souffrait d'anxiété et de dépression. Dans un article Embody Equality, Sigma Safety and Justice, Clément Glasson, Disability Justice Legacy, on nous réfère à la décision de Stewart versus Elk Valley Cole, dans laquelle le juge Gascon a écrit une opinion dissidente, dans laquelle il mettait en exergue le caractère politique de l'invalidité et la façon dont le litige s'était engagé dans ce dossier-là, mettait en évidence la réticence de la société à s'attarder à l'invalidité et aux considérations complexes qui entourent le droit à l'égalité lorsque la toxicomanie est en cause. La dissidence du juge Gascon est une analyse critique de la loi et de la politique de la justice pour les personnes handicapées. L'accent mis par le juge Gascon sur la stigmatisation est important et répond à un obstacle de longue date dans la défense des personnes handicapées. On doit comprendre que le fait qu'il était lui-même porteur d'un handicap a augmenté sa sensibilité. Comme ma collègue le mentionnait, la juge Abella a, tout au long de son travail, démontré comment on devait être plus ouvert en ce qui a trait aux questions d'égalité. Alors, je vais me passer, je vous ai mentionné que la justice était quand même pas mal homogène. Au Québec, nous n'avons pas de statistiques à cet effet. Et aussi, c'est un endroit qu'on pourrait qualifier de white space. Alors, les conséquences d'une justice homogène. Au Canada, la magistrature est quasi homogène. Il s'agit d'une culture juridique professionnelle dominée par des juges de race blanche dans laquelle il existe une tradition de déférence qui empêche la dénonciation des jugements et de leur discrimination. Cette homogénéité de la magistrature a pour conséquence que la culture juridique professionnelle est dominée par un groupe dans lequel il existe une tradition de déférence, comme je le mentionnais. Pour comprendre le déficit de représentation, il faut prendre acte des faits historiques, notamment du fait que certains groupes se sont heurtés à des obstacles alors qu'ils voulaient devenir membres du barreau. La professeure Backhouse réfère notamment à la classe ouvrière, aux hommes noirs, aux juifs, aux autochtones et aux femmes. Ainsi, la notion de professionnalisme a été historiquement et est toujours inextricablement liée à la masculinité et la blancheur, le privilège de classe et le privilège de classe. Et on voit que le système favorise ce type de candidature dans le cadre de la dénomination à la magistrature. Le spectre du professionnalisme, je pense qu'il est important de mentionner, comme je le mentionnais tout à l'heure, que le professionnalisme, on ne peut faire abstraction des effets ou encore des contraintes de l'éducation juridique. Et à la socialisation professionnelle, les avocats sont censés adopter un moi professionnel qui subsume tous les autres aspects de leur identité personnelle et morale. Les avocats criminalistes, par exemple, les avocats criminalistes ont souvent mentionné, là je fais un saut parce que je coupe un peu, parce que c'est un peu long. Alors, je pense que c'est important aussi quand on regarde la question de qui est professionnel, je pense qu'en travaillant le texte, je me suis rappelé la décision de la Cour d'appel de l'Ontario où 2 avocats noirs avec un stagiaire s'étaient présentés à la bibliothèque et où ils avaient été profilés racialement par la bibliothécaire qui considéraient qu'ils ne pouvaient pas être avocats. Donc, on leur avait demandé leur carte d'identité et ils avaient été profilés dans l'enceinte même du palais de justice. Puis cette situation-là s'est produite dans les années 2000. Je pense que c'est important de voir comment on perçoit qui peut être avocat, de quoi a l'air un avocat. Je vais m'attarder plus particulièrement sur le processus de nomination des juges, puis si on a le temps, on regardera un petit peu la formation. Quand on regarde le formulaire de nomination des juges qui contient 25 pages, plusieurs questions sont posées, puis plusieurs éléments doivent être étayés par ceux qui veulent devenir magistrats. Or, quand on regarde ce formulaire-là, en lisant le formulaire, on constate que celui-ci opère comme si les avocats racisés ne sont pas confrontés à des obstacles systémiques qui ont d'ailleurs été documentés au fil des années, notamment dans le rapport sur l'égalité dans la profession juridique de l'Association du barreau canadien. On comprend à la lecture de ces rapports que les avocats racisés qui veulent pratiquer sont confrontés à une course à obstacles ou encore à un jeu de serpent échelle. Leur progression de carrière est semée d'embûches, de pièges auxquels le racisme n'est nullement étranger. Le rapport soulignait que, j'ouvre les guillemets, ce qui est de plus troublant aujourd'hui, c'est que malgré les progrès formels accomplis au niveau de la légalité juridique, malgré l'adoption des principes non racistes, nous ne soyons toujours pas parvenus à une profession racialement intégrée. À la lecture du formulaire, on a la nette impression que le profil des candidats recherchés est celui des avocats exerçant dans des grandes firmes ou encore dans des grandes organisations qui offrent du soutien au développement de carrière et notamment aux avocats la capacité d'avoir des sponsors. Le formulaire remet de tenir compte du fait que pour les personnes racisées, il existe des obstacles systémiques, par exemple l'accès à des dossiers intéressants ou encore le fait d'obtenir un sponsor ne va pas de soi. C'est un exercice qui est périlleux et difficile. Le formulaire demande aussi qu'on demande à savoir s'il y a eu des publications, si l'avocat en question a publié des articles scientifiques. Je ne peux passer sous silence que dans certains cabinets, on donne accès à des ressources aux avocats seniors afin qu'ils puissent écrire des articles et que souvent, il arrive que ce sont des stagiaires ou encore des recherchistes qui produisent des projets et qui restent dans l'ombre. Des dossiers portés en appel, c'est faire abstraction du fait que le système judiciaire en tant que tel est un système excessivement coûteux et ce ne sont pas tous les avocats qui font partie des groupes racisés ou avocats autochtones qui sont en mesure d'avoir des clients qui vont avoir les moyens d'aller en appel, tant devant la Cour d'appel que devant la Cour suprême. En ce qui a trait au pro bono, on sait très bien que dans l'exercice de pro bono, les avocats racisés font énormément de pro bono dans leur dossier puisque leur clientèle est souvent défavorisée, mais ce n'est pas le type de pro bono qu'on valorise, ce serait plus un type de pro bono qui est directement relié à certaines causes. Et lorsqu'on parle de certaines causes, c'est des causes qui ont une exposition plus large. Par exemple, on pourrait prendre le cas de l'affaire Fissures, par exemple, mais ce ne sont pas nécessairement les avocats racisés qui auront accès à cette ressource. Charge d'enseignement, on prend pour avéré que tout le monde peut enseigner. Or, peut-être pour les écoles du barreau, c'est peut-être possible, mais en ce qui a trait aux universités, la porte n'est pas grandement ouverte. On demande aussi des références des juges pour pouvoir… Or, ce sont des cercles, le cercle des juges est un cercle qui est plutôt fermé. Si les avocats racisés ont une clientèle défavorisée, généralement, souvent, on peut constater qu'effectivement, ils vont faire plus de modes alternatifs de règlement différents, ce qui ne sont pas sanctionnés par les tribunaux. Et de toute façon, c'est un peu paradoxal parce que le Code de procédure civile, par exemple, du Québec, incite les avocats à passer du côté des modes alternatifs de règlement. Ça fait d'ailleurs partie des obligations qu'on a comme avocat. Donc, c'est quand même assez particulier qu'on demande encore des références des juges, qui est un cercle quand même assez fermé. Et ça ne tient pas compte aussi de la discrimination qui existe dans le système, dans le sens où, puis je vais en parler un petit peu plus tard, dans la mesure où il arrive que des juges eux-mêmes font l'objet de comportements préjudiciables à l'égard de certains avocats. Et puis que dans la mesure où, puis je donne un exemple concret, dans un dossier, une avocate racisée m'a rapporté que dans un dossier, elle est obligée d'aller en appel parce que le magistrat qui siégeait en première instance ne voulait pas l'entendre et lui coupait la parole. Donc, elle a dû aller en appel pour que les droits de son client soient respectés. Donc, est-ce que cette juge-là ou ce magistrat-là va lui donner la référence dont elle a besoin pour pouvoir être nommée juge? La question se pose, alors qu'il existe déjà des blocages. Et d'ailleurs, ça m'est arrivé à moi aussi où j'occupais dans un dossier, un dossier de longue durée, et les avocats de la partie adverse m'ont souligné que le juge me traitait de façon différentielle. Lorsque j'ai posé la question, qu'est-ce qu'on fait avec ça? Les avocats m'ont mentionné que puisque c'est un dossier de longue haleine, leurs clients ne pouvaient pas changer de juge, les coûts étaient trop élevés, et que conséquemment, j'ai dû plaider devant un juge qui avait été jugé par mes collègues qui l'observaient, qui avait considéré que j'étais traitée de façon différentielle. Cela a des conséquences non seulement sur l'avocate ou l'avocat racisé, mais ça a des conséquences pour le client. Alors, quand de telles situations se produisent, il faut se poser la question, est-ce qu'un client a intérêt à se faire représenter par un avocat racisé devant le tribunal? Et la question pourrait, ensuite, qui doit assumer les frais quand un appel est déposé parce qu'un avocat racisé fait l'objet de blocage de la part d'un tribunal? Qui doit assumer ces frais? Donc, on voit les conséquences de la discrimination puis la notion un peu de ripple effect. J'aimerais vous parler de la formation des juges. Je ne mentionnerai que la loi sur les juges a été modifiée afin que les juges qui viennent d'être nommés suivent une formation sur le contexte social, puis sur les agressions sexuelles. Or, cette formation-là n'est pas...
Time is up, so a minute if I can request you to wrap up.
OK, I'm wrapping. So, la formation de tous les juges. Alors, je vais sur ce, je vais rapper, puis je vais juste finir en disant, il y a une dizaine d'années, en 2008, c'est-à-dire, le professeur Tanovich parlait de whiteness of the charter. Force est de conclure que les conclusions qu'il avait dans son article sont toujours applicables. Je vous remercie.
Merci, Tamara. Sorry to interrupt you.
That's okay.
It was a fascinating account, and it gives us some real life examples of where we need to be shining the light on in terms of systemic racism, if we can dare to use that word in today's context. I thank all the panelists for their insightful comments, their critical reflections on the theme of interpretive complexities. I'd like to open the floor now to our audience members, and I will start with one question that I've already received. In the meantime, please don't hesitate to raise your hand and I'll keep a note of the questioners list. So I'll start by asking the question that I received in the chat. And this is a question for Professor Sheppard. How can we differentiate substantive equality and inclusive equality?
Okay, thank you for that. Well, the language that the Canadian Supreme Court uses with respect to Section 15 has been to elaborate a concept of substantive equality. In other contexts, including in some of my own work, I've actually suggested that we should be attentive to a concept of equality that we could label inclusive, which would be attentive both to the substantive dimensions and effects of inequality, but would also look at the processes that result in the reproduction of inequalities. And it reminds me a bit of François' insistence on empowerment, that in fact it resonates with Tamara's concern with the lack of diversity in our judiciary, that it may not be a solution to leave equality up to some substantive definition by judges, but rather we need to think about how to empower those who have been historically disempowered to participate in the public policy and processes for creating the decision-making structures that would end the cycles of inequality. So I guess inclusion speaks to the importance of substantive equality. Also often focuses on substance, which is critical, substantive effects of group-based disadvantage. But I think it's also important to be attentive to the processes and the need to include those who have historically been excluded in developing the solutions for the reproduction of inequality. I mean, I guess in some ways that goes to Joshua's presentation too, in terms of a shift from rights to jurisdiction in thinking about Indigenous rights.
Thank you, Colleen, for that. And I'll pass to Sebastian.
Yes, I have two questions. One is for Colleen specifically. If you can comment on the reluctance of Justice Abella to recognize family status as the ground for discrimination. she says something like, there's not enough evidence at this point, this is not the right case, but it seems like this would have been the perfect case to look at that issue. And then for all three panelists, and I guess this is also kind of connecting to my thinking on Fraser, to what extent do you think that courts need to develop more innovative remedies to deal with systemic and structural forms of oppression and discrimination? And I guess I'm thinking, if I'm looking at Fraser and I'm looking at this, you know, at a broad level, I would say, of course, the pension plan discrimination should be resolved, but it sounds like what you need is an affordable and excellent daycare system to be set up as well, to sort of at the root level eliminate this discrimination based on who bears the burden of childcare. So I would like also to hear your thoughts on to what extent can courts develop innovative remedies to deal with the structural causes of the forms of harm that we're discussing here.
Okay, shall I start then, Vrinda, on the?
Yes, please go ahead.
Okay, well, on the family status, I think that the court may well recognize that in the future. I don't think it's hugely controversial. I think that it has been included and has been addressed in a number of human rights tribunals interpreting human rights legislation. There has been divergences in some of those tribunal decisions and court decisions about the degree to which we should accommodate family responsibilities and some of the complexities of what that might mean if we recognize family status. So I think in this case, because it hadn't been fully briefed, the court decided to not go down that path, although Justice Abella tried to sort of suggest that we could do a robust intersectional analysis between family status and gender in this case, but I think it's mainly because there are a number of complexities that have emerged at human rights tribunals that hadn't been fully discussed in the Fraser case. So I guess in terms of the innovative remedy, should I keep going, Vrinda? I think that's absolutely critical. And remedies that go to process issues and structural issues, that as well as substantive issues. But your concern, the other issue is to what extent can you use litigation as a mechanism for dealing with larger structural patterns of inequality? And I don't think litigation is going to be a panacea for that. There are limits to the kinds of remedies. For example, there was an important human rights tribunal decision involving sexual abuse of migrant workers in Ontario. And one of the concerns was, well, the whole foreign migrant workers program should be changed, but the Ontario Human Rights Tribunal compensated the victims or the survivors who had been subjected to the assault, sexual abuse, but said, I don't have jurisdiction to change the migrant workers, the foreign migrant workers program. So there are limits, I think, to what you can do through litigation, but I think certainly attentiveness to those structural issues is critical. On the daycare issue, just on the Fraser point, some of the RCMP women who were job sharing were in rural areas where it was very difficult in terms of access, even if childcare was particularly difficult in that context. So.
Thank you, Colleen. If I could just add to that, Sebastian, I think that maybe she could have, Justice Abella could have thought about family status even in the context of her opinion in Quebec versus A, and I think she was gearing towards that if she had had a little bit more help from the lawyers before her, perhaps. Would any other panelists like to respond to Sebastian's question, or should we move to the next one?
I'd actually like to respond. I think the question about the relationship between remedies and the judicial assessment of the nature of the problem that they face is an interesting one to consider. I think that in a lot of Section 35 cases, the court has a tendency to lean towards the weaker side of remedies and look towards declarations like Manitoba Métis or compensatory damages. A new case coming out of BC, the BC Supreme Court called Rio Tinto, where the Indigenous party is looking for the removal of a hydroelectric dam that was installed without any consultation or compensation back in the 1950s. And there's a good clear line of legal reasoning that would lead them to a substantive and innovative remedy of that kind. And instead, the judge laments that they didn't ask for damages, right? Whereas when it comes to Quebec cases, right, secession reference, Manitoba language rights, they're quite innovative with remedies. And this reminds me very much of how, when you read Cherokee Nation out of the Marshall trilogy, it's a case about standing. It's the one case out of the trilogy with an Indigenous party before the court, looking for standing as a foreign nation within the definition of the US Constitution. And the only judge that accepts that they do have that standing is Justice Thompson, supported by Justice Story. And he uses an interesting thought experiment to flush out the main issue before the court. And he says, what if on Cherokee lands in Georgia, it wasn't the Cherokee, but they were Spaniards? What remedy would it be? Right. And so I think that stands to be considered about the kind of remedies that go towards Quebec and that kind of constitutional reconciliation, and the kind of remedies that go towards Indigenous peoples.
Interesting. I think that it probably also goes to Tamara's point about the importance of social context in adjudicating these kinds of claims. So we have the next question from Noor. Go ahead, Noor, please.
My question is for my former professor, Colleen Sheppard. I was wondering specifically, I appreciated the discussion of Fraser and the importance of Fraser more broadly in advancing substantive equality as well as adverse impact discrimination. I'm interested in your thoughts about the technical change to the Section 15 test, and in particular, the move away from the contextual factors under the second step of the Section 15 test, and what sort of impact you think that's going to have on discrimination claims moving forward. Have some of those factors, do they still play a role under Section 15, or have they been shifted to the Section 1 analysis? So more of a kind of technical question there for you.
Yikes, I'm trying, okay. This is the Interpretive Complexities panel. So I'm trying to remember the 4 contextual factors. The court moved away from them slowly, never did, in the CAP case, as you know. But I guess some of them I think are still relevant to and because the court continued to emphasize the importance of a contextual assessment of the second step of, after one identifies some distinction relating to a ground or enumerated or analogous ground, looking at the substantive inequality that might be perpetrated or result from the policy or law. And part of that requires a contextual analysis that may speak to the historical disadvantage of the group. I think that some Section 15.2 has stepped in, and it was in that CAP case in particular, to take up some of the considerations that was initially included in those contextual factors. There's another issue, though, that's kind of technical, and that goes to, I think, a continuing confusion about whether something should be assessed under Section 15.1 or under Section 1 as a reasonable limit. And you see this, I didn't highlight it in the divergence between Abella and Brown and Rowe, but Brown and Rowe bring in a language of arbitrariness or unreasonableness. That's at the heart of their assessment of the part that job shares should, it's reasonable to treat them as part-time workers because they're only working half-time. And they move into that kind of an assessment, which was contemplated, they link it to one of the factors in the Nancy Law case. Abella says, no, we need to shift the arbitrariness assessment and whether it's reasonable or unreasonable back into Section 1, which is where Justice McIntyre initially wanted to put it in Andrews. And so they have that debate. What's important from a substantive equality theory, because I don't want to get into too much of the nitty-gritty details, is if substantive equality is concerned with historical disadvantage, exclusion, harm, not necessarily about whether it's rational or irrational. And bringing a language of reasonableness or arbitrariness into Section 15 undermines that dimension of substantive equality. So Justice Abella once, even though sometimes she used language of arbitrariness in some of her other judgments, but in Fraser, she tries to push it clearly back into section 1, and that's where the government has the burden of proof of showing that a particular kind of harm may be reasonable. And it may be in this modern social welfare state or regulatory state, it may be that the state can't do everything. But so I don't know if that answered your questions, but I don't want to bore everyone with these technical details on section 15.1.
Thank you, Colleen. I think it's fascinating, particularly because Abella seems to put the adjective arbitrary before disadvantage in so many of her recent opinions that is causing some consternation for court watchers. So I have a question for Tamara. So Tamara, just given the context of Justice Ketanji Brown Jackson in the United States, how long before and what would it take for us to have a Black woman or a woman of color on the Canadian Supreme Court?
First, I don't think that we have any woman of color in the Court of Appeal. So it will be difficult to have. And I think that, we have to look at, go back to the pipeline. So how can we build a pipeline? What kind of pipeline do we have as the Superior Court judges? We have now 2 Superior Court judges in Quebec. In the Court of Quebec, we have 1 Black judges only, and the situation is not very good at this point of time. And I'm referring to the comment of Justice Dortelus when he left the court. He said he was making representation to the court, to the Minister of Justice, saying that there's a lack of representativity in the and diversity in Quebec. And the question of Quebec is very complex, and we don't want to go with all the discussion that we hear in the news every week. But that's the question. The question has become not the pipeline saying that we don't have good lawyers, visible minority or Black judges, Black lawyers, but the question is how those women which are placed in an intersectionality position can go to the bench, and after that, what kind of cases they get in the bench. It's the same story, like repeating. So I think that those structural problems are still present, and we have to. And I think also it's not only a question only of government, but sometimes we have to have a strong organization to push, like for visible minority, Aboriginal people, and in the question of there was a question of the nomination of an Aboriginal judge lately at the Supreme Court. Those questions has to be raised because it's a question of. And I will quote the Prime Minister, we are in 2022. That's it.
Thank you very much. I'm just going through the chat. I don't see any questions, so I'll take advantage of the lull in the questions to pose a question to Josh, please. So Josh, I wanted to ask you what your thoughts were in the recent case. I'm afraid I don't remember the name of the case, but with regard to the US citizen from Washington state and that decision that he had the right to hunt in Canada. I was rather taken aback by the use by the Supreme Court, the Canadian Supreme Court, of the Vanderpeet test so many years later, and so kind of boldly and brazenly. And I was just wondering what your thoughts were about that.
Yeah, I mean, I think it's an interesting. The name is also sort of escaping me right at the moment.
It's Desotel.
Restool comes to mind, but it's not Restool. Sorry?
Desotel.
Desotel, yeah. Yeah, I mean, I think it's a somewhat interesting case because there is some innovation in it in terms of its remedy, but I think in large part embraces the same set of problematic tests. So there's a lot of status quo to it. So it has this kind of mixed flavor that a lot of the jurisprudence has. There's a kind of 1 step forward, almost 1.5 steps back kind of motion. And so there are things that you could use in other cases if you dropped a lot of the other background that's in it. I mean, even really positive cases like the new case from the Quebec Court of Appeal, the reference, still has the idea that there would be there's something inappropriate about having Indigenous jurisdiction that requires provincial jurisdiction to overlap it and then have a Section 35 test, right? Because the one part of the federal bill that they reject is the one that it would entertain the idea of exclusive Indigenous jurisdiction. And so, while they seem to support self-government, not really consistently. They still are reliant on this charter approach that doesn't actually have an idea of what self-government would really mean. Yeah.
So I have a related question, seeing as I don't see any other hand raised. And that is, how can we shake off the persistence of this doctrine of discovery?
I think in a sense, it's really just holding our jurisprudence to the standards that we supposedly espouse and embrace in other areas, right? So if you look at the Section 9124 case law, and this is inclusive actually of the Quebec Court of Appeal in this case, when they talk about Section 9124. Now, what you see when they talk about it is that we don't see a principled interpretation of the meaning of the words in the act, within the scheme of the act, within the historical context of 9124. Instead, we see a description how governments have used that power.
Right.
Now, that's a strange form of interpretation. You see it in Daniels too. Governments have used it to do. Now, does that mean it's a prerogative head of power in the sense of it just takes its shape from however a government chooses to use it? And is a court who's doing that kind of interpretive work a court that is giving the color of legality to basically illegal behavior, right? So I think just holding our system to the standards that it supposedly espouses in a clear and consistent fashion is all that's required. And some courage in the judiciary to actually give us the meaning of Section 9124 in a principled way, and either say that they will never question the rights and they are going to conflate settlement with conquest as a doctrine, which the Australian courts effectively do in Mabo,
Right.
or go to the rule of law.
Yeah. Thank you for sharing your thoughts on that. I'm going to open up to other panelists. Please don't be shy. This is your chance to question our three legal experts on this area.
Well, I might ask a question to Tamara. Parce que j'ai trouvé que votre discussion ta discussion de le formulaire de 25 pages, comment est-ce qu'il faut changer ça? Est-ce qu'il y a une façon, parce que j'étais étonnée, j'avais pas rempli le formulaire. Mais alors, c'est juste parce que c'est vrai que quand c'est systémique, ça veut dire que c'est juste,
ça renforce.
Ouais, il y a comme un tas de choses qui sont impliquées. Alors, comment est-ce qu'on peut reformuler le processus de la sélection des juges, par exemple, pour assurer une diversité plus répandue?
Premièrement, comme tout formulaire, le formulaire a le but de restreindre le bassin aussi en même temps. Je veux dire, dans le fond, la question qu'on doit se poser, c'est de dire, est-ce qu'il y a des meilleurs outils? Moi, je ne suis pas psychologue industriel, mais dans le fond, c'est de revenir, qu'est-ce qu'un bon juge? Et qu'est-ce qu'on valorise comme étant un bon juge? Évidemment, il y a des compétences techniques qui doivent exister, mais on sait aussi que la nomination des juges, il y a aussi beaucoup de choses qui rentrent en ligne de compte, puis c'est pas, je veux dire, il y a des avocats qui sont dans l'ombre qui feront peut-être de meilleurs juges dont on ne connaît même pas l'existence. Parce qu'il y a la participation au barreau canadien, au barreau du Québec. Il y a un ensemble de faits qui fait qu'à un moment donné, il y a des gens qui font le travail tous les jours, qui seraient en mesure de comprendre les complexités de certains dossiers, mais qu'on ne voit pas. Est-ce que c'est un processus d'entrevue? La réponse, c'est oui et non, parce que ton processus d'entrevue, il y a encore les biais qui viennent jouer. Donc, la réponse, ça doit être une réponse qui est multiple, puis il faut aussi se poser des questions, à savoir quels sont les réels besoins de la magistrature. Est-ce que puis le système français n'est peut-être pas une réponse? Est-ce que le système hybride est une réponse? C'est-à-dire à savoir, est-ce que les juges doivent avoir une formation de juge, puis des éléments pratiques du fait qu'ils ont pratiqué? Est-ce que c'est une option dans une société où la complexité du droit est aussi importante? Quels sont aussi les skills qu'on a besoin comme juge? Est-ce que l'intelligence émotionnelle n'est pas un facteur qui joue? Est-ce que c'est pas des choses? Donc, c'est un travail dans le fond, c'est de sortir, parce que les formulaires, l'avantage, c'est que ça donne l'impression de neutralité et d'objectivité. Ça, on le sait. Je pense que là-dessus, il n'y a pas de doute qu'on pense qu'on a quelque chose de plus neutre et de plus objectif et de plus justifiable. Mais après ça, est-ce qu'on peut unpack ou encore est-ce qu'on peut considérer qu'on veut avoir des personnes qui viennent de l'aide juridique, est-ce qu'on veut, sans vouloir parler de quota, mais des fois, je pense qu'il faut être capable de dire quelle mosaïque de juges veut-on créer? Parce qu'en ce moment, on n'a pas de mosaïque et je pense qu'il faut aller chercher l'idée d'avoir une mosaïque et celle-ci devrait être en partie professionnalisée, mais c'est parce que ce que j'entends, moi, des gens qui sont nommés, c'est qu'il y a une absence de compréhension du contexte social et même une résistance de compréhension de celui-ci. Et dans le cadre, par exemple, si on regarde la question dans le dossier RDS, le juge en chef, la maire, avait fait des commentaires relativement aux Asiatiques et aux Roms qui avaient été convoqués devant le Conseil de la magistrature. Bon, ça n'a pas eu donné de suite, puis on peut comprendre le contexte. Mais quand il est venu la question de dire est-ce qu'on devrait avoir des cours de contexte social du droit, le juge en chef s'est objecté parce qu'il considérait qu'on allait endoctriner les juges. C'est que c'est des juges qui devaient former les juges. Alors, quand les juges ne comprennent pas les questions systémiques parce qu'ils ne sont pas exposés, et là, on est dans toute la question de dire, color blindness, le fait que ça, comme malheureusement, puis heureusement, c'est malheureusement pour la personne qui est racisée, puis heureusement pour la personne qui bénéficie du privilège, mais les personnes qui bénéficient de privilèges ne voient pas ces privilèges-là en action. Et ça, c'est problématique quand tu es sur le banc parce que tu es dans un milieu uniforme et qui ne te challenge pas. Puis là-dessus, la professeure Constance Backhaus a souligné certains traits de la magistrature qui sont hautement critiquables. Elle a parlé de certains narcissiques dans ses articles. Alors, c'est tout ça qu'il faut, je pense qu'il faut remettre ça, il faut s'asseoir, il faut consulter. Évidemment, la réponse ne peut pas venir d'en haut, la réponse doit venir d'en haut et d'en bas, puis d'essayer d'obtenir une magistrature qui est capable de remplir toutes ses obligations. Moi, c'est comme ça que je pense que la réponse, c'est à peu près ça.
Merci.
Merci, Tamara. I was just going to say, give the last question to Professor Poirier, and we will then go ahead. Please, Professor Poirier.
Sorry, I'm keeping you all away from lunch. This is just a fantastic.
That's okay.
I cannot tell you how wonderful this has been. Chacune des présentations est extrêmement riche et m'a fait réfléchir. I have a question for Joshua. Yeah, welcome back. About your interpretation, the interpretation you're proposing for 91-24, which I think is really interesting and thought-provoking, and what it means for the current division of powers and how we backtrack. Because if I'm understanding well, and I'm sure it's more sophisticated than this, but how can I say this? You're undividing the crown. And we've been used for 150 years to have a divided crown. So how do we do this? How do we basically pull the provinces out of that equation? Or am I misunderstanding what you're suggesting?
No, I don't think you're misunderstanding. I think there's an inertia within the Canadian constitutional order that takes 91-24 as it stands, which effectively, I think, created basically what a scholar like Ernest Frankel studying the Third Reich would call a dual state within Canada, right? A separate but equal state. And so a lot of pragmatic talk about the court being somehow unable or its hands are tied or it can't give a principled account because it just would be too hard to push the provinces out. It doesn't stick much with me. I think that we already know how to do this. Section 35 was supposed to be spelled out in constitutional conferences that failed. Mm-hmm. And because of that, the very thing that the Penner report, back in 82, when the Senate was tasked with mapping out what Section 35 might mean, they suggested that the federal government occupy and vacate 91-24, right? Use its power to push out the provinces, basically paramountcy. and then vacate it in order to basically remediate, decolonialize our constitutional order. The federal government chose not to do that. In the Penner report, they caution that if they left it to the courts, the process would be uncertain and circuitous. Right? A lot of ad hoc patchwork modification, but no principled push to actually reconsider because of this structural problem. I don't think it's redividing the crown. I think it's bringing the crown to an honorable position that it took when it negotiated treaties.
No, I meant undividing the crown, not dividing, undividing, bringing it back sort of to a unity, which of course, you know, from a provincialist perspective would need to be discussed. But I understand what you're, you know.
In a sense, it's like undoing St. Catherine's Milling, and that's really hard work, because really St. Catherine's Milling creates the idea that 9124, the provinces have the land, right, and the federal government has the Indians. And we're doing the work of undoing that.
That's right.
And the provinces are the biggest sticking point. Like, one of the best things you could do to critique this area of law would just be to create a public database of every factum the Crown has argued in the last 150 years. It would testify against itself, right? Because they're using the same arguments. They get recolored by the 1970s. They exclude certain terms, but the force of those terms, the logical force of those terms, remain in Crown arguments. They still argument the same thing every time in court. And they're relying upon a judicial standard that has the consistency of the chancellor's foot. They can just roll the dice. Uneven tables costs a lot of money for Indigenous peoples to litigate.
Of course.
Yep. So.
Yeah. Thank you.
I don't know if that's an answer, but.
Well, it's certainly an invitation to carry on this conversation, because
it's a hard one.
You know, as we talk about the importance of jurisdiction and power, which I think permeates every one of the presentations today, that it's not only about courts. And if it's about courts, then we need to know who's in the courts and so on. So a lot of it is about empowering and jurisdiction. Mm-hmm. Well, recreating and empowering and recognizing inherent jurisdiction that was abolished unilaterally in such an undefensible way, it is of course something that you might want, that we might aim to correct and find strategies for. The question is, what's the cost for the rest of the country in doing this? And I'm not saying that that cost is more important. I'm not saying that at all. I'm just saying there has to be a conversation, because the assumption in a way seems to be that the federal government would do a better job. And that's a conversation I'd really like to have with you in the longer term. I think it's easier maybe to correct, historical mistakes with one voice, and the nation to nation paradigm works better that way. Mm-hmm. But whether there would be more will to do things properly in Ottawa than there is currently in BC, I'm not sure.
No, and I don't think I would characterize it that way either. I mean, I'm talking more institutionally. I'm not talking about how they actually behave. Yeah. If we look at how modern treaty negotiating tables are run by the federal government at this point in time, they've adopted the language of recognizing Indigenous law. And yet when they're pressed on where it fits in relationship to provincial and federal, they admit that it's categorically somehow distinct and overwhelmed by provincial and federal. And then when they're pressed about the legal hierarchy, they reject the hierarchy language, but retain the form. Now, when lawyers do that kind of thing, which is just logically inconsistent, there's something wrong with their argument. We're talking about hierarchy. If you want to redescribe it another way, fine, but it's still a hierarchy because it has the same operative function. I agree. And so the federal government likes to talk out of both sides of its face. The provincial governments like to talk out of both sides of their face. And the responsibility of the courts is to provide an actual legal interpretation of the Constitution, which we don't have. Mm-hmm. So everyone washes their hands and one party sits. And so I think that's the situation.
Merci. Thank you very much. So on that note, I think I would like to draw this interesting session to a close regretfully. Just a few closing remarks. I think that through today's presentations, we've questioned the utility of a rights discourse We've heard words like precarity, vulnerability, voicelessness, and marginalization. These came up, all illustrating the disjuncture between rights and reality. We also see how the dissent of Brown and Rowe in Fraser threatens to undermine substantive equality as we know it. Yet 40 years on, the attraction of rights, their symbolic and real value, particularly to those who are disadvantaged and disempowered, continues to provide hope and optimism. Indeed, we also heard words like transformation and equality. I thank you, the audience, for your active and thoughtful engagement with the issues that were raised and discussed today. And I'd ask you to please join me in thanking our distinguished panelists, all the morning session and this session as well. Thank you very much for sharing your thoughts. It was very enlightening. Thank you.